Hi friend, welcome to the Company Law Adjudication and Appeal Series. Today we are discussing Cuttack ROC adjudication order in the matter of the InDNA LifeScience Pvt for the violation of section 102 of the Companies Act. Dear friends, in this case company name is InDNA LifeScience Pvt having registered office at Bhubaneswar, Odisha as per the MCA record, and in so-called notice and reply and personal hearing, the directorate conveys sanction for the initiate action for the violation of section 102 of the Companies Act and company's share capital and debenture rules on the basis of the inquiry report submitted by this office. Accordingly, so-called notice issued to the company and its officer, its director. In response to the said so-called notice, company furnished its reply as the reply furnished by the company is not found satisfactory. Therefore, notice of inquiry was issued dated 18th February 2022 pursuant to company adjudication of penalty rules to the company and officer or directors, calling upon them to appear personally or through authorized representative on 3rd March 2022. Let's see the provision of the Companies Act. As per the section 102 of the Companies Act, which provide that a statement setting out the following material facts concerning each item of a special business to be transacted at the general meeting shall be annexed to the notice calling such meeting. The nature of concern of or interest, financial or otherwise, if any, in respect to each item of every director and manager, every other KMP and relative of the person mentioned above, and any other information and facts that may enable members to understand the meaning, scope, and implication of the item of the business and to take decision thereon. For the purpose of subsection 1, in case of the AGM, all business to be transacted thereat shall be deemed as special other than the four items: consideration of the financial statement and report of the board of the director and auditor, declaration of dividend, appointment of director and in place of those retiring, and appointment and fixing of the remuneration of the auditor. In the case of any other meeting, all business shall be deemed to be a special. Whereas any item of the business referred to any document which is considered at the meeting, the time and place where the document can be inspected shall be specified. As per the Rule 13, Sub-Rule 2, Clause D of the company's share capital and debenture rules require the company to make a specified disclosure in the explanatory statement to the next to the notice of the general meeting pursuant to section 102 of the Companies Act. However, it is observed from the notices on different date filed through the Form MGT-14 for convening of the EGM for further issuance of the equity share on preferential basis that the company has not complied with the all requirement of the said rule. Whereas in the view of the above, the company thereby contravenes the provision made under section 102 of the Companies Act. Every promoter, director, manager or other KMP are liable for penal action as per provision of section 102 subsection 5 of the Companies Act. On the fixed date, authorized representative appeared before the adjudication officer and requested to consider the submission made in earlier letter as it was inadvertently left or to be annexed to the notice, which apparently does not effect. Further, he has stated that the relevant provision seems to be not applicable to private company as per the ministry or notification dated 5th June 2015 and also the provision made in the articles of association of the company. As the company has admitted its default, having considered the facts, circumstances and documentary evidence of the case, and after taking into account the factors above, the adjudicating officer considered view that the company has violated section 102 of the Companies Act and Company's Share Capital and Debenture Rules 2014. Hence, the adjudicating officer do hereby impose penalty on the company and director officer in default as per table given below. On the here the penalty imposed on the three director, which is officer in default, for the violation of section 102 and rules, 50,000 each on the officers in default. The company and its director are hereby directed to rectify the default immediately from the date of the receipt of a copy of this order. The penalty imposed shall be paid through MCA portal only. Appeal, if any, prefer against this order in writing to the regional director within period of the 60 days from the date of the receipt of the order in Form ADJ, setting for the grounds of the appeal and accompanied by a certified true copy of this order. In case violation of the this order, non-payment, then in case consequences under subsection 8 of section 454 is attracted. Thank you so much for watching this update. In case of any query or needs judgment copy, you may download a link given in the WhatsApp message below the WhatsApp message. Thank you so much.